off the record for a moment. Everyone, we are on the record. People need to whisper. And if you're behind the court reporter, you need to ask the deputy. Hypothetically, yeah, I committed a theft, but let me tell you why I committed that theft. I'm starving or something of that nature. I'm trying to feed my children. Doesn't mean that you didn't do it. It just means that you're trying to say, Judge. Kaylin Gutierrez.
He wants to address the court about my ability to represent him, Your Honor.
Okay.
How are you doing, Your Honor?
I'm doing great.
Today's my birthday.
Oh, happy birth month. You know, I think that everybody should celebrate the entire month.
Yes,
I
ma'am.
think, Mr. McCray, you recently had a birthday.
I did, Your Honor.
Well, I'm
62 at this point.
62. You look awesome for 62, I must say.
Thank you, Judge.
You know, the older we get, the more certain ages are not considered old. I think 100, that's not old at all. Well, I'm making my way towards 60.
Judge, don't you have a birthday month?
I celebrate the entire month. Now, mind you, I only celebrate the month. Other people decided that they were going to start at the end of October and continue through December. That's not me. That's other people, but I'm accepting of it because I don't want to disappoint anyone.
Holiday.
I just want that one day, Your Honor.
You just want one day?
Yes, ma'am.
Well, see, my problem is my birthday is at the beginning of the month. And when you think about it, it's like, you only get one day.
That's all I want, Judge.
You know, I always tell people you should celebrate the entire month because when you were born, I'm sure you at least gave your parents a month of joy. You know, they were probably like, oh my gosh,
No,
smile.
I don't know that first one,
Okay.
especially on the first one. It's sort of like, oh my God.
I'm like, what have I done? What do we do? We don't know how to do this. All right. So let me explain something to you. I don't know what your issue with your attorney is, but I'm going to tell you what I've told every person who's been before me, right?
Yes, ma'am.
I've been a defense attorney. I've been a prosecutor.
Yes, ma'am.
Now, I've run my court a certain way because when I was a defense attorney and a prosecutor, you pick up things from other judges and then you decide what you feel would work and what you would have liked if you were a defense attorney or prosecutor.
Yes, ma'am.
So in this court, I require that I make sure that everybody have all their discovery. Of course, we're not going to be up in here a year waiting for discovery, right?
Yes, ma'am.
Then the other thing I require that attorneys receive offers from the state.
Right.
And when your attorney receives an offer, ethically, they're obligated to give that to you. Now, you may think that offer is ridiculous, right? But I tell people, let's not say those words because then people get here. And I want everybody to be at this level when they negotiate. So if your attorney gives you an offer, that's the offer the state has made. Defense attorneys, this is what people think. Defense attorneys believe sometimes, defendants believe sometimes that defense attorneys can control what offer the state is going to make. They really can't. All they can do is they could present maybe mitigation to the state and say, hey, this is why you should consider giving this person probation. Or either they can present something to them and say, this is why this case should be dismissed.
Yes, ma'am.
And then you know what the state will do? In this court, I will tell you the state will consider the argument that the defense is making.
Yes, ma'am.
And you know what they could say? You know what? You're right. We're going to dismiss it. Or you know what? You're right. The offer that we're making is too much.
Yes,
That's
ma'am.
what they may say.
Yes, ma'am.
Or they may say, no, this is the only offer we're making. And then once your attorney presents that offer to you, you have one or two choices. You can say, I'll accept it, or you can say, I won't accept that, but let me make a counter offer. Tell the state I'm willing to accept A, B, and C. And then your attorney will let the state know he won't accept that, but here's a counter offer for you. And then guess what? The state can say, oh, let's consider that. And they can say, yeah, we'll accept this counter offer. They can say, no, the only thing we're offering is A. And then your attorney will bring that back to you. And then now you have a choice. Either you're accepting what the state's offer or either you want a jury trial. That's the thing. Now, I can tell you, some attorneys have great bedside manners. What do I mean by that? They sit with you, they hold your hand, they talk to you about how your day is going, how's your family doing. There are some attorneys, they're not into that. They're like, I'm here about this specific case. These are the elements the state needs to prove. These are the facts I have. and this is police report. Let me defend you. So that's where we are.
Yes, ma'am.
So what is your issue?
My issue is Mr. McCray would not let me get one word in. Judge Boyd, I wanted to at least speak my testimony.
All right, so let me talk to you about speaking your testimony. If you're speaking of your testimony is something that you want to present to me,
Yes.
the only time you're allowed to present that to me is if you decide to testify. And I'm sure your attorney has told you that's completely up to you, whether you testify or not.
Yes, ma'am.
And I'm sure Mr. McCray has probably told you the good things and the bad things if you decided you wanted to testify, right? As far as speaking to me and saying, oh, my case should be dismissed, and here are the facts that I want to tell you, this is not the part of the process where I received that information. The part of the process where I received that information is if you have some kind of mitigation. For example, if you say, yeah, I could hypothetically, yeah, I committed a theft, but let me tell you why I committed that theft. I'm starving or something of that nature. I'm trying to feed my children. Doesn't mean that you didn't do it. It just means that you're trying to say, Judge, go a little light on me because let me just tell you about my life.
Okay.
All right.
Yes, ma'am.
So
Yes, ma'am.
that's the only time. So for you to be telling me what you think the facts of your case are, guess what? If you want to tell me stuff right now, anything that you say can be used against you at jury trial. That's where this ends up. So sometimes attorneys are trying to protect clients from themselves. I've had plenty of clients where I've had to protect them from themselves. And then some of them like, you know what? I'm still going to do my own thing. And I'm like, an explosion is going to occur and you're going to get the blowback from it. So you understand?
I do now. Yes, ma'am.
All right. See, sometimes we just need to.
I just need to talk. I'm sorry. This is my life and this is a very important day. I'm sorry.
No, here's the thing. Every single case is extremely important. People tell me sometimes I take too long on cases, but you know what I tell them? The person who's standing before me, this is extremely important to them because it's their life. This is a criminal court. You're looking at probation or you're looking at prison time. You understand?
Yes.
So that's where we are.
Yes, ma'am.
So is there any other issues with Mr. McCray? So then the next thing I need to discover from both parties is where are we on discovery? This is where I'm trying to figure out if your attorney has received everything from the state that he needs to adequately and professionally represent you, okay? All right, so is there any outstanding discovery that you know of, Mr. McCray?
Not that I'm aware of.
All right, have you been, lately there's been an issue with downloads. Have you been able to download everything?
Yes, sir.
All right. State, were you able to tender an offer?
I said there's a today only offer.
Okay, so here's the thing. The state has tendered an offer to you. I'm going to have you sit in the box and internalize it because the state is saying that offer is for today. That's it. So I'm going to give you a chance to discuss that with your attorney. And if you decide you don't want to accept it, then we'll move towards a jury trial. Okay.
Okay.
All right. Thank you.
Thank you, ma'am.
You're welcome. All right. Tyler Ashbaugh.
Morning, Judge.
Good morning. How's it going?
It's going good. How are you?
All right. It's
Well.
always great seeing you.
Too.
All right. So on this case, I guess we're headed towards jury trial.
Well, I believe the setting for today was a final discovery matter. I do have a motion to present to you. I've conferred with the state.
Sure.
It's a motion to permit us to access and examine the scene of the alleged offense, Judge. And the reason I'm presenting this to you now, and I know it seems like it's coming a little bit late, is because I never anticipated that this would become an issue.
Okay. So when you say the scene, why do you need my permission to go out to the scene? Where is the scene alleged to be?
And I'll explain that to you, Judge. I never thought I would be in a position where I would be having to ask the court either.
Mhm.
The scene, this would be in a church parking lot.
Okay.
And so I'm not asking to go into anybody's residence, anything that I would consider, or I
Well,
don't.
here's the thing. State, are you objecting to this? Because he has a right to go out to the scene.
Because no, we're not objecting to it, but it's, I believe, a private property, so we cannot enforce anything on that.
So, and if you let me explain, Judge.
Sure.
So, we were ready to go to do our investigation. We were anticipating taking photographs, videos, measurements, these types of things. It's my position that what we would, and I anticipated that what we would be getting would be exculpatory in nature. I fully believe that. Now, our investigator called the church just to give them a heads up. We didn't want them to be surprised, like, hey, who are these people that are going out there that are, taking videos and photos? We wanted to let them know and be upfront with them. And however, my investigator spoke with the pastor, and it was his position that he did not want us to go out there, and he was not going to allow us to
All
go
right,
out
so let me
there.
ask you this. Which church is this and who is the pastor?
It is on O'Connor Road. It's called something Calvary Church,
All right, what's the full name of the church?
and the pastor's name is Matt Lighty, Leighty. I have his phone number.
All right. I'll have a seat and we'll take that up.
Okay, so just need to get him on the phone, and when
Yes,
he's on speaker, let the court know.
yes,
Judge, can I reapproach on my case?
yes. We're gonna do McKinney, and then after McKinney, it's gonna be Patterson. Mr. McKinney, come down. All right, so, Counselor, you're hired on these?
Judge, Tony Jimenez was appointed, now I'm appointed. Apparently, we think the indicted case, the one that's set today, may be with intake on the other case. There's no file today. I want to see if we could recall it for tomorrow morning.
Okay,
Mr. McKinney and I talked, I have a little better understanding of what we're dealing with, but I'd like to look at the file.
all right, we won't be able to call it for tomorrow, but we can recall it for Thursday.
I'm in Kendall County on Thursday. Could we do Friday?
No. But, I mean, you want to do it November 4th?
I have a out of town hearing, and then I've got a hearing on that Cotter case with the MAG office.
All right, the 7th?
I should be able to, if we can do it early. I'm gonna start a murder trial on the 5th and the 4/37th, but I don't think they start till 10.
All right, if you're ahead, we'll take you up at 9:30 on the 7th.
Okay, I'll be here.
All right, Mr. McKinney, this attorney has recently been appointed to represent you, so they need to make sure they have discovery and everything. You understand?
Yes, I understand fully. Ms. Boyd.
All right, do you have any questions about anything?
If you would allow me, I'd like to bring to the court's attention my recent, re-magistration.
All right, that's something, because that's legal, that's something you'll need to speak to your attorney about.
No, I understood. It's just why I have the opportunity to establish a record, considering that he just got appointed at that time. Mr. Jimenez was my attorney. The magistration was held with me not having any counsel.
So let me explain something to you, and if I'm wrong on the law, I'm sure your attorney will correct me. But when you're magistrated, it's not an adversarial process. The only thing the magistrate judge is doing is telling you what your rights are and setting a bond.
From what I'm aware of, it's Supreme Court ruling stating that you are allowed the assistance of counsel through all criminal proceedings.
Okay.
And in that particular matter, I was negated that right under the Sixth Amendment of the United States Constitution.
All
So
right,
I
if
just
you,
like to get the court's record established with that.
no problem. We can put that on the record if you want to put that on the record.
Yes, now I would love to. Please.
Sure. All right, court is calling 2024 CR 009238, 2024 PF 16224, and 2024 PF 16225. State of Texas versus Raymond Lee McKinney. Can I have parties announced for the record for the state?
And fair settlement.
Defense,
Robert Mauer for defendant.
are you Mr. McKinney?
Yes, I am, Ms. Boyd.
All right, can you raise your right hand for me, please?
That'd be difficult. And
Well, no, because I need to swear you in.
okay,
You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
no disrespect to the court, Ms. Boyd.
Well, here's the thing.
I don't swear. That's why I'm trying to bring to
Alright.
your attention. I don't
All
swear.
right, let me ask you this. Do you affirm that you will tell the truth and nothing but the truth?
I guarantee to the court that I would definitely tell.
All right.
And
You wanted to
that I
place
won't
some,
do.
you wanted to place something on the record?
Yes, ma'am.
You may proceed.
I'd like to place on the record that I was recently magistrated by Judge Ramirez. It was this past Thursday or Friday, if I'm not mistaken. And I was without counsel. And from my understanding, the Sixth Amendment grants you the right in all criminal proceedings to be able to have this assistance of counsel, which I didn't have during that re-magistration. During my first magistration, counsel was provided through the public defender's office, and that was negated in this recent re-magistration. So I want to just make sure that it was brought to the court's attention and the record was established with that. So there could be an objection that the court was notified of in that regard.
All right, you said something interesting. You said that the public defender's office was present?
In the first, and that was
Okay.
June 14th
Okay.
of this year.
All right. Defense, is there anything you wish to add?
No, Judge.
All right, thank you for letting me know.
Yes, ma'am. Thank
And
you.
there's a record and it's been preserved, okay?
Yes, ma'am.
All right, thank you.
Yes, ma'am.
Thank you, Judge. I'll see you on the 7th.
All right, thank you.
Also excused.
Yes.
Thank you.
All right, court is calling 2024 CR 009696, State of Texas versus China Renee Gonzalez. Can I have parties announced for the record for the state
Andrew Harris Edelman.
defense?
Renee Munoz.
And are you Miss Gonzalez?
Yes, ma'am.
Counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Counsel, is this an application for deferred?
It's an application for straight community supervision, Your Honor. I just didn't know how the court preferred it, so I just did both, that it was one.
All right, thank you. Did you review the document entitled Application for Community Supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
You're gonna need to keep your voice up.
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Ms. Gonzalez, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions? Off the record for a moment, everyone, we are on the record. People need to whisper. And if you're behind the court reporter, you need to ask the deputy to move you. Do not talk behind the court reporter. All right, we're back on the record. Did you review the court admonishments and defendants waivers and affidavit of admonitions with you?
Yes, ma'am.
All right, everyone, I'm sorry, off the record for one moment. I need to speak with this pastor.
Oh,
Yes, Your Honor.
Just have a seat. All right, so this is on Ashball.
Yes, it's on, you just gotta tap that. When it's-
Oh, well, I see it. Excuse me, Pastor? All right, Ms. Gonzalez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
State, are you all waiving the repeater enhancement allegation?
Yes, Your Honor.
All right, any objections?
No objection.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes,
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. The state will take in consideration 2024 CR 009697, 2024 PF 17269, 2024 PF 17270, and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes,
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years and there be a participation in Esperanza Court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence.
Stated in exhibit one in attachments, Your Honor.
No, Judge.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, briefly. With regard to my clients, upon myself first meeting her, and our first visits, I knew that there were some issues present. You know, she's in the yellow, she is pregnant at this time, and she is charged with, drug offenses, which led me to believe that there might be issues with substance use disorder, Your Honor. I did also see prostitution in her criminal history, so I did take it upon myself to, ask the court, previously, which granted to, have her referred for Esperanza Court. I know Esperanza Court does great work. I've worked with them some times in the past, and they have evaluated her, deemed that she does meet criteria. And in an email from Ms. Perez, Natalie Perez, the case manager, stating that if the court would consider granting her with the condition of Esperanza Court, that they are willing to accept her into that program, Judge. So I spoke with my client and explained the Esperanza Courts, the criteria that has to be met to get in and what would be expected of her if she is in the program. And she is willing to abide by that. She wants to change her life around, not only for herself, but for her unborn child and for children she has as well, Judge.
All right, how many children do you have?
I have 3.
And who are they with?
I gave up my daughter for adoption and my son's with my stepfather, and then I'm pregnant right now.
All right, and who is this Antonio Pablo?
That is
Hernandez?
my kid, that's my first kid's father.
All right. So I'm ordering no contact with Pablo Antonio Hernandez. And that's based upon what's in the police report. Take in consideration 2024 CR 009697, 2024 PF 17269, 2024 PF 17270. There'll be a referral to Esperanza Court. She's to remain in custody until transferred. Regular reporting by Zoom or in person, regular random UAs. If not accepted into Esperanza Court, then I want her brought back to court. So she is only to be released to Esperanza Court. When's the last time you had employment?
Oh, I have my own lawn care business.
Right, everybody's doing lawn care. Yeah, let me just tell you, that's gonna stop. You're gonna have to have a business. You understand?
Mhm.
And when I say a business, if you're doing lawn care, you need to have a DBA and all of that. Otherwise, I'm not accepting that. You're gonna have a job where you actually get a W-2 or whatever. You understand?
Mhm.
So there's gonna be
Yes, yes,
proof
ma'am.
of employment within 45 days. There's to be no employment as a home health care provider or with minors. CPS compliance. Is CPS back in your life? They probably will be, counsel. I'm gonna want field visits 1 time per month until further notice. There's to be 200 hours of community service restitution. I'm gonna order parenting classes. Once parenting classes are completed, the restitution will be deemed satisfied.
That restitution, Judge, is that 200?
200 community service hours restitution. There is to be 2 years in the prison, suspended and probated for 4 years. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
Thank you, Your Honor.
Have a
Maybe
good day.
And just 1 second. Oh, she can go back in the box.
Yeah, approach Your Honor.
I spoke with the pastor and he just basically gave me a list of days and times that are no-go times, but other than that, he said, whenever we're free.
All right, so then there's no need for the court to sign an order?
He's in agreement now. I don't see the need. He's agreed. If it becomes an issue, I'll present it again though. Well, I think to be safe, I probably should get it signed because he did.
Well, let's just see. You know, I always say, once you give people legal paperwork, then people get their hackles up. So he said that he's gonna allow you to come out
Yes.
with different times.
Yes.
If there's an issue, just come back to the court.
Okay, fair enough, Judge. So if we could just get one, hopefully, final reset for discovery this time.
All right, so when, do you have a specific idea?
I don't. I have to coordinate with our investigator on a time that's good for him.
All right, so I'm gonna give you guys the time. This is gonna be the last time.
Right.
November, we call this for November 12th. Yes, sir. And that's the last discovery unless the pastor says he's not letting you out.
Okay.
Okay.
Fair enough, Judge.
All right, thank you.
Thank you. And actually, my client had a request. He's on, I believe, GPS partial just for work,
Mhm.
but his wife is now
Have
attending.
you already addressed?
It's something else, Judge.
All right, have you confirmed with the state?
No, I have not.
All right, you need to confirm
Okay.
with the state. All right, thank you. Thank you for addressing appropriately for court.
Yes, Your Honor. You have a blessed day.
All right, thank you, you too. Are you ready? Okay, all right, Gucci, oh,
Yes,
ma'am.
yes, ma'am.
am I pronouncing your first name correctly?
Island, yes, ma'am.
All right.
I'm sorry. Yeah, it gets real confusing. You did it right though. Thank you very much.
You are so welcome. All right, court is calling 2024 CR 009938, State of Texas versus Kylan Michael Gutierrez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense,
Your Honor, Todd McCray for Mr. Gutierrez.
and are you Mr. Gutierrez?
Yes, ma'am.
Counsel, have you received all of the discovery?
Yes, Your Honor,
Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Gutierrez, did you review the document entitled Application of Community Supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
I did, ma'am.
Counsel, do you waive the reading of the indictment?
I read it to him and we looked at it together, Your Honor. Yes, ma'am. We'll waive it.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the repeater status, proceeding on it with as a second degree felony.
Any objection?
No objection. That's part of our agreement.
Mr. Gutierrez, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
I did, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with unlawfully carrying a weapon with a felony conviction? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
I did, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Gutierrez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. The state opposes your application for probation. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, were there any such motions?
No, Your Honor.
Outside the agreement, or if the court were to grant your application, there's a request for a TAP evaluation. Did you understand that was a recommendation and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor.
Again, which I've reviewed thoroughly with Mr. Gutierrez and we find no objections.
All right, state you may be excused. Did you review the waiver and consent to stipulation of testimony with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
All right. Off the record for a moment, could I have parties approach? I never put my lips on the hose, though.
I remember those times.
Yeah, those were good times,
Those are
right?
good times. Those are
Yeah.
good times.
Yes, no problem.
I'm not from here, so I kind of know.
Thank you.
And I reviewed that report with Your Honor and we find no objections.
All right. Bar Stapler, please.
Thank you. And Judge, would you like us to put it on the record that we?
Yes.
Okay.
All right, we're back on the record.
And Judge, the state is offering about 5 additional pages for state exhibit number 1 with its attachments. We've asked for it to be entered. We disclosed that to defense. And also it's been stapled to state exhibit number 1 with its attachments.
And those are the original police reports, again, which I reviewed with Mr. Gutierrez and we found no objections.
All right, thank you. Then the state will accept it into evidence. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Counsel, it is taking about 8 weeks for a PSI. If you would like, we can have him back sooner. I can just request that a TAP evaluation be done. You'll have time to bring in whatever witnesses you want, and I'll ask for the criminal history from the state.
I think that'll be fine, Judge, satisfied with that.
All right, Ms. Abrams, 2 weeks? All right, I need a 2-week reset. And just, we're back on the record. And for the records, defense, are you waiving the PSI report?
Yes, Your Honor, but you're gonna do the TAP evaluation?
Yes.
Yes, ma'am.
I can do November 14th.
It's fine.
All right, so we're gonna come back on November 14th, counsel. And
Is that okay?
Mr.
Yes,
Gonzalez, I mean, so Mr. Gutierrez.
Yes.
So this is what will happen on that date. I'm gonna have a TAP evaluation, will tell me any drug issues that you may have had. And then the state is gonna bring me your criminal history. And then your counsel will have a chance to present witnesses if you have witnesses that you want me to hear before sentencing. All right, do you understand everything?
Yes, ma'am.
All right,
you
then
so much.
you're welcome. We'll see you on November 14th, okay?
Yes, ma'am.
Thank you.
Thank you.
And where's Mr. Aguilera? All right, if he'll come forward, just want to be sure. All right, so where are we on discovery?
Judge, there's some medical records that I was just retained about 3 weeks ago, and there's some medical records I'm trying to get to the state, based on Mr. Aguilera's most recent medical situation. He was arrested, at the time of his arrest, he was taken to the University Medical Center, was in field custody there for about
Mhm.
a week or so.
So those are the records you're asking for?
Yes, Judge, and he had a surgery that I think, from what I can tell, removed part of the leg.
Okay. All right. We're gonna bring this back in 30 days. That will be the final discovery date. I need a 30-day reset for discovery. You want to just put it on December 2nd? All right, so we're gonna come back on December 2nd. All right, is there anything else?
No, thank you.
All right, so other than that discovery council, you've received all the discovery from the state?
I believe so, Judge, yes.
All right, then once you sign the reset form, you are excused.
Thank you.
Thank you.
Thank you, Judge.
You're welcome. Thank you.
Thank you, Judge.
Thank you. And Mr. Aguilera, thank you for dressing appropriately for court.
Thanks in the name of the person we're giving you. Right? Okay. Oh my goodness.
You're welcome. Galaxy, Maria, Guerrero Alvarez.
Ready, Your Honor.
Thank you. All right, court is calling 2024 R010330. State of Texas versus Galaxy Guerrero Alvarez. Can I have parties announced for the record for the state?
James Seeloff for the defendant.
And are you Ms. Alvarez?
Yes, Your Honor.
Okay, so parties for the discovery acknowledgement, I have a PF number. Is that the same case?
Yes, Your Honor.
Yes, Your Honor.
All right. So counsel, have you received all of the discovery?
Yes, I have, including all the misdemeanor cases that we're gonna take into consideration.
All right. And did you review that with your client?
Yes, I have. I took what they have.
All right, court will find that the state is in compliance with discovery. Ms. Alvarez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Alvarez, did you review the court admonishments with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with injury to a child elderly disabled with intentional bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Alvarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2024 CC 736223, 2024 CR 009623, County Court Cause Number 731512, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
That's our plea.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you what drinking alcohol and doing drugs does to your unborn child?
Yes, ma'am.
Well, let me ask you this, because people say that and they really don't internalize it. Let me ask you this. Your 2-year-old, your 4-year-old, would you let them drink alcohol?
No, ma'am.
Would you let them do meth,
No,
heroin,
ma'am.
or anything?
Mm-mm.
Well, guess what? Your unborn baby, you're giving that child alcohol, you're giving that child drugs. That has to stop. Because I've done CPS cases before and I represented children before.
Yes, ma'am.
And you know what ends up happening when children are born addicted to drugs? They go through withdrawals. Have you ever gone through with? Result in me losing custody of my children? If the answer is yes, then you should not be doing it. Do you understand?
Yes, ma'am.
If you need anything, just let the court know.
Yes, ma'am.
All right, you're
Thank you.
excused. Thank you.
Thank you very much.
Everyone, we're taking our recess. We'll be back at 1:30. Yes.
I'm sorry. My client was just able to call me. He's got 4%.
Okay.
I was wondering if I could put him on speaker because he doesn't think that he'll have enough power to log on to Zoom.
Okay. Well, let me ask you this.
Yes.
Is he, does he
Hold on.
want a jury trial?
He wants an offer that the state is not willing to give at this time.
All right, so this is what we're gonna do. We're gonna recall this. We're gonna recall it for Thursday.
That's fine.
All right, thank you.
I'm sorry, Your Honor.
That's okay.